Court does call the case People versus Shawn Dorsy.
That's calls for the people.
Assault and battery to 93-day offense. Upon his plea to that charge, count one would be dismissed. There is also the boxes checked, but it's there.
Here we go, People versus Shawn Dorsy. The stakes? A misdemeanor assault charge. But watch closely, this isn't just a simple plea deal. The fine print could completely change Dorsy's future.
There's no delayed deferred for a. However, defendant is able to enter to a treatment court for a term of his probation. People will agree to prosecutor's deferred sentencing.
That's correct, Your Honor. I also make a record at this time that the people would also like to see a mental health referral and follow all those sorts of treatment recommendations as part of this defendant's probation, but that is not an element of our agreement. It's required.
Is that a correct statement, Ms. Young?
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to give the whole truth and nothing but the truth? Yeah. State your name.
Shawn Dorsy.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of assault and/or assault and battery. That's a misdemeanor. It is punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your, well, do you understand what a no contest plea is, sir?
Yes, Your Honor.
All right. Two things I have to make sure that you understand is that, first of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand that although I'm taking your plea, I would not be your sentencing judge, and you would.
This is where the reality hits. Up to 93 days in jail might not sound like much compared to felony time, but for someone without a strong support system, that's life-altering. And here's the kicker. Once you say no contest, the court treats it just like a guilty plea.
Be sentenced before Judge Washington in the 14B District Court.
Yes.
Basis for the no contest plea.
Lack of memory, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form?
Yeah.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what was stated here today on the record to get you to plead no contest?
I'm sorry. I don't understand what's happening, but
So-
sure. Yeah.
You don't understand what's happening?
Am I going to treatment? I've been told twice I'm going to treatment.
Okay, so hold on a second. Do you understand that right now you're entering a plea to this charge?
Yeah. The no contest to misdemeanor.
Okay.
That's what we're talking about.
Yeah, that's what I'm talking about right this second, but you're indicating you're not sure what, I guess I'm on.
I just didn't hear but the last thing you said. That's what I was confused about. The last thing that you mentioned.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Dorsy's confusion shows how overwhelming these hearings can be. Judges move fast, legal terms fly around, and defendants often feel like passengers instead of drivers. Would you fully understand what you were agreeing to in this moment?
All right.
No, I don't. Yeah. I'm just, am I doing my,
What
is this,
Go
are
ahead.
you guys trying to have me do drug court or treatment?
So-
Or that's what I'm confused.
Right, as part, here's what the court understands. All right, that you're going to enter a plea. They really haven't made the treatment court part of the agreement in this case, although it is noted on the plea form that if you can get yourself into a treatment court, they agree to a prosecutor's deferred. Okay, but the agreement is not contingent upon you getting into the treatment court. That makes sense to you?
Yeah,
Okay, does that answer your questions? And sir,
I think
you're in the
so.
middle of, okay, well, hold on. You're in the middle of this plea, so if you want me to pass it so you can talk to Ms. Yagi some more, so that you're absolutely clear about what you're doing, I don't have a problem doing that. I
Okay.
have to make sure you understand what you're doing and that you're clear on everything.
Yeah, she's explained a lot to me. I'm very clear for sure on that.
Okay, so you
Yeah.
don't want more time to talk to her about this?
No, I think you just explained it too. I understand now. So thank you. Appreciate it.
So whose explanation was better, mine or Yagi's? No, don't answer. Don't answer. All right. So, sir, has anybody promised you anything other than what we stated here today?
No,
Has anybody threatened you or coerced you in any way?
no, sir.
All right. You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yep. Yes, sir.
Okay. The court had been provided and has reviewed Washington County Sheriff's Office report for their case number 25-49864. Counsel, there's no objection to the court reviewing their report, is that correct?
No, Your Honor.
All right. Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to apprise you that if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that the Judge Washington in this case would no longer be bound by any sentence evaluation and or recommendation. You understand that, sir?
Yes, sir.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which
Now, here's a procedural bombshell before even sentencing. The judge looks at the sheriff's report to confirm there's enough evidence for guilt. This is why no contest is so powerful. It avoids a trial but still locks you in legally.
caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 25th at 10 a.m. for Judge Washington.
September 25th, 2025, 10 a.m. before Judge Washington.
Your Honor, may I address bond?
Briefly.
Okay, first of all, I do actually, I talked about this with Ms. Feltz. I do have a stipulation and proposed order for release to treatment that I would ask the court to sign. He's very eager to get into treatment. I was going to ask for a PR with the understanding that Mr. Dorsey is seeking treatment himself. Even without the court order, even if the court was to release him today on a PR, he would still go to treatment because he knows that's what he needs and that is what he wants. And we've had a lot of genuine conversations about that. So I would ask the court to consider he has no criminal history, no other holds, no probation, parole. He's been in 36 days. Obviously his sentencing is not for another month. So I would ask if the court would consider a PR with testing, very strict testing requirements, and even a bond condition that requires him to submit proof that he's going to treatment and meetings. One of the things he said to me that really stuck out to me is he's used to going to multiple meetings per week, like at least 4 a week. In the jail, he's only able to go to 1 a week. And he said that's not enough for him. And that's one of the main reasons he's eager to prove his commitment to recovery is by going to more.
This is Dorsey's best shot at freedom before sentencing. His lawyer pushes for a personal recognizance bond, banking on Dorsey's willingness to attend treatment. Sounds reasonable, right? But wait until you hear the prosecutor's counterpunch.
Frequent meetings on the outside when he's able to.
Response.
Your Honor, I am opposed to a regular PR bond. The release to treatment makes sense to the people, but the issue here is that the victim in this case is the defendant's mother. She's present in the courtroom. She is elderly, very Plea, and I'm concerned about the way in which the assault battery was played upon her before I know I was read the police report. So that's a great concern to me. Also, I don't know where the defendant will be staying. That was his home and he's not welcome back there. So there's a concern of where he'll be. I
would love to see the treatment happen before his sentencing date. But a regular PR release bond gives me great concern for her safety, as well as the defendant's stability and ability to have a place to live while he's out.
I'm gonna leave that to Judge Washington.
That's the jaw dropper. The victim isn't just anyone. It's his own mother. Suddenly, this case isn't just about addiction recovery, it's about family violence. How do you balance second chances with protecting the very person he hurt?
And if after the point at which he's interviewed or assessed and Judge Washington feels he can be released, then that's fine. I think she'd have the same question for where he's gonna stay and the like. But at this time, I'm gonna deny the request for a change in bond will be. Thank you.
Thank you.